Hi and hello everyone. Today we are going to understand about section 151 small shareholder director as given in chapter 10 of Companies Act 2013. Small shareholder director are appointed to protect the interest of minority holding. They act as a representative and watchdog of small shareholders. Small shareholders mean shareholder holding nominal amount of 20,000 or less. While considering this limit, both equity and preference shares are considered. It is not compulsory that small shareholder director must be appointed. Firstly, this is applicable only for listed company. So, every listed company may or may not have one director elected by small shareholder. Now, understanding about the procedure for appointment. The company may appoint small shareholder on its own or on the basis of application received from small shareholders. On its own, there is no condition, but on the basis of application, notice in writing has to be given by at least 1,000 small shareholder or 1/10th of the small shareholder, whichever is less. And this notice should be given at least 14 days before general meeting. The content of the notice would be name, address, number of shares held by the person who is proposed to be appointed as the director. The following notice should be accompanied by statement which is to be signed by the person whose name is proposed for the post of small shareholder. The notice would state his DIN number, he is not disqualified to become director, and 3. His consent to act as directorship. If the proposer does not hold any shares in the company, the details of shares held and folio number need not be prescribed in the notice. A person can be appointed as small shareholder director whether or not he himself is a small shareholder. So, it's not necessary that the director must be a small shareholder. He can be other than small shareholder or he doesn't even hold shares. A listed company may elect small shareholder through postal ballot. There are some restrictions for appointment of small shareholder. Number 1. Small shareholders director can be appointed for maximum of 3 years and need not retire by rotation. He cannot be reappointed. Number 2. A person shall not hold office as small shareholders director in more than 2 companies at the same time. Number 3. Person who is small shareholder director in one company cannot be appointed as small shareholder director in second company if it is in competition business or in conflict with the business. Number 4. Small shareholder director, whether directly or indirectly, not to be appointed or associated in any other capacity with the company for a period of 3 years from the date of cessation as a small shareholder director. Number 5. Small shareholder director is not eligible for appointment as full-time director or managing director of the company. Here manager is not used because the manager doesn't come in company. Number 6. Such director shall be considered as independent subject to his declaration of independence. So, he must fulfill the criteria of section 149(6) of the Companies Act, which talks about the independent director requirements. And also, he must give the declaration for being considered as independent director in first board meeting after his appointment. Point 7. The person appointed as small shareholders director shall vacate the office if he incurs any of the disqualifications specified in section 164, if the office of the director becomes vacant under section 167, or the director ceases to meet the criteria of independence as provided in section 149(6). Now, let us understand about the removal of small shareholder director. Small shareholder director can be removed only by passing ordinary resolution in general meeting. We must see the compliance of section 169, which talks about removal of director. Small shareholder director can be removed with majority consent of all the shareholders of the company. Special notice will be given by at least 1% of the total voting power or aggregate sum of not less than 5 lakhs. It shall be given not earlier than 3 months but at least 14 clear days before the date of meeting. Immediately after receiving the notice, it shall give the members a notice of the resolution at least 7 clear days before the meeting. Where it is not practical to give the notice, it shall be published at least 7 days before the meeting in English newspaper or vernacular newspaper and shall also be posted on the website. And the director will have right to make representation in writing. So, in a general meeting, after regular item of business, the matters given in the special notice will be considered. And if ordinary resolution passed, the director stands removed. And that's it from my side. Hope you found this informative.